Hold on. Did we just hear that right? The defense is actually arguing that hitting a dog is a form of First Amendment expression. It's a bold move, Cotton. Let's see if it pays off. We're starting this case with a legal argument, so wild it makes the dog ate my homework sound like a Supreme Court precedent. Stick around, because this gets much darker before it gets better.
While I'm not saying that what she did is acceptable, I just don't think it rises to the level of being as it may have appear on the video. Repeatedly, a dog is conduct, and conduct is protected by the First Amendment.
So you're saying a dog is a form of speech?
Humans don't even get that level of protection.
I don't, because the state is asking for jail time.
First, the price was $300. Then it went up and up again once she realized that it would be an inconvenience for her to not break even.
Understand?
Is that just during probation?
Yeah, I mean, I can only order what I can order and no gum chewing. I can only order what I can. If you are a pet owner, then you can poison your pet. That's not a crime.
Now to an update on a disturbing story we had to bring you last night. A 23-year-old woman was arrested after being caught on camera allegedly beating her 3-month-old puppy. It made its rounds on social media and she was arrested and charged with animal cruelty. Today she did bond out of jail and that dog is still under Animal Care Services care and they are investigating. The night team Zaria Oates talked to a woman who was there when ACS removed that dog from her home.
Made me very angry.
A video sparking outrage online.
When I tell you to come here, you do that.
This is the heart of the outrage. While the lawyers argue over semantics in a climate control courtroom, the reality is a 3-month-old puppy being allegedly tormented on camera. The neighbor's quote really hits home. If this were a child, there'd be pitchforks and bonfires. Why do you think society sometimes treats animal cruelty as a lesser crime? Let me know in the comments.
You can see a woman yelling at a small dog several times. We aren't showing the video in its entirety as it's difficult to watch. 23-year-old Havana Miller was charged with 1 count of animal cruelty. It can carry a sentence of up to 10 years in prison. As the video made its rounds online, a friend sent it to Geneva Story, a dog rescuer in San Antonio. Story was at Miller's apartment complex when San Antonio police and Animal Care Services took the dog away.
Here they come. They have the baby. There's a lot of times where people are like, I want to mind my business, but this is one of those situations you don't want to mind your business of. I mean, if it was a child, people would be jumping in and gung-ho about it, pitchforks and bonfires and burning the building down. I feel like a lot of people see it's a puppy and they just kind of turn the other cheek.
All right, so we're here today to hear pretrial motions. I think it is best to start with the motion to quash, because if that were to be granted, then the other motions will not need to be heard. So the court is in receipt of the true bill of indictment, and the court is in receipt of the motion to quash the indictment and a memorandum in support of the defendant's motion to quash the indictment. State, are you prepared to proceed on the motion?
Yes, Your Honor.
All right, defense, you may proceed.
Yes, thank you, Your Honor.
Oh, you can remain seated and if you'll speak into the microphone, that way I can hear and the court reporter can hear.
Thank you. All right. So the issue with this statute is very specifically in regards to the torture provisions of 42.092. And what I mean by the torture provisions is in 42092B1, it says that if you commit torture or in a cruel manner kill or cause serious bodily injury, that provision, we're limiting it to the torture because the state has not alleged cruel manner of death, killing, or serious bodily injury. The definition of torture is an unjustifiable, an act that causes unjustifiable pain and suffering. And while that might sound, sufficient, it's super, super vague. And it becomes even more vague when you look at the rest of the statute and how in the allowable conduct that it permits under the statute. So I do have a copy of the statute, and it says a person commits an offense if the person intentionally, knowingly, or recklessly, without the owner's effective consent, kills, administers poison to, or causes serious bodily injury to an animal. So by implication, if you
Okay, let's break down this terrifying legal glitch. The defense is pointing out that the Texas statute is worded so poorly, it implies you can legally poison a pet as long as the owner, who is often the abuser, says it's okay. It sounds absurd because it is absurd. The defense is trying to quash the indictment by proving the law itself is too vague to be enforced. Is this a genius legal loophole or a desperate reach?
have the owner's effective consent, it is not illegal to kill, poison, or cause serious bodily injury to an animal. Then, if you proceed downwards, it allows under B6, it allows that someone, if they have the effective owner's consent, to cause an animal bodily injury.
So are you saying that according to this part of the statute, if you are a pet owner, then you can poison your pet, you can beat your pet, and that's not a crime?
And that's what is concerning about the absurdity of this statute, but that is the statute. Basically, what it's saying is if somebody else does it to your animal and you give them consent, it's okay. But read it, and that's what I'm saying. It says under B, a person commits an offense if the person intentionally, knowingly, or recklessly, without the effective consent of the owner, kills, administers poison, or causes serious bodily injury. So they can do it. It's not as long as they have the effective consent of the owner. So
isn't that related to if you take your doctor in for veterinary care? Well, you euthanize, have the animal euthanized, that you're killing the animal and the owner has given consent?
And that's a great question. But if you look further, it actually has a provision that deals with the like a veterinarian services. And let me see, it is a defense on D. Mm-hmm. It is a defense under that if the actor had a reasonable fear of bodily injury, if the actor was engaged in a bona fide experimentation of scientific research, or under E, if it was discovered on the person's property, or 2, the person killed, injured the animal within the scope of the person's employment as a public servant. And then, so, I mean, I don't see where it says actually a doctor, but you see what the problem there is that by saying, oh, that's just to allow a doctor, it is not limited under the statute for that purpose. It's saying anybody. And when you look at animals are considered under our statute or under our laws as chattel, as property, which is just the way our society has defined them. Whether I agree with it or I don't agree with it, the civil courts will not allow you to collect money, civil damages, for the loss of your emotional attachment to a dog. And there's a case that we have on that. It's cited in the paper. We can provide that to you. So what they they do a great job of.
Well, that's civil. We're just here under the penal code.
Yes, Your Honor. And so, but the point is that the status as property is what is triggering the owner's, why you have to have the owner's effective consent, because our laws.
This is the cold, hard truth of the legal system. In the eyes of the law, your dog is technically no different than your toaster or your car. They are property. The defense is using this to argue that since you can't criminally cause emotional pain to a toaster, you shouldn't be charged for causing it to a dog. It's a cynical argument, but legally, it's a massive hurdle for the prosecution.
Whether they are civil or criminal, still see animals as property. They don't see them as having the same rights as a human.
But are you, even with regards to this section that says without the owner's effective consent, are you arguing that you can steal animal in a cruel manner?
I'm not arguing that. I'm saying, yes.
Or cause unjustifiable pain?
So that part I am arguing with, because that is so broad as to undo all the other rights that you would have. Because when you say unjustifiable pain, does that go to emotional pain? It's not limited. It doesn't even and that's why this is going to become such an issue throughout the course of this trial, is because if, as in our case, there's no bodily injury, then you are saying that the law allows for us to criminalize acts that someone just feels cause a dog unjustifiable pain and suffering without requiring any proof of bodily. Humans don't even get that level of protection. You know, humans, you can't be charged for having caused someone emotional, like with a crime, for having caused them emotional injury.
Is the indictment, are you all charging this indictment as causing emotional pain to the animal?
No, Your Honor, the indictment's charging under the first section under D1 that says torture.
All right. So they're not, my understanding, and if I'm wrong, please correct me. My understanding is nobody is charging her with causing emotional pain, allegedly causing emotional pain to an animal.
So if you have no body to an animal, then what's left?
Isn't that a fact issue for the jury?
No, I don't believe so. I believe that our law will not allow, like, written as broadly as it is in conflict with every other provision that we have in our codes. Because if you look at, like, for instance, a human assaulting another human, we specifically state in our definition of bodily injury that it is the
Causing pain?
Yeah.
Is one of them.
It's causing pain, but the thing is that it also it will not allow for someone to be criminally prosecuted for emotional harm or pain. And we distinguish that by saying that it has to cause bodily injury. Here, the problem with this statute is that torture provision does not require bodily pain. If anyone shows that there was no bodily injury, whether, and it's a different topic, whether you could include pain or it would require physical bodily some type of visible injury, that's a completely different issue. But just assuming for the sake of argument that if we are going to require and limit assault human, we definitely can't not require it for an animal who, under our laws, has historically and still today gets less protection. I mean, a prime example is our horse racing. We have animals that are routinely raced and beat with crops. And the reason I bring that up is because this one specifically names repeatedly striking a dog. That's the manner in which they claim. So the point is that our society has said it's justifiable to beat a horse with a hard crop.
The whataboutism has entered the chat. The defense is literally comparing striking a puppy to hitting a racehorse with a crop. They're essentially asking, why is it a crime here but a sport there? The judge isn't having it, though, reminding them that the legislature, not the court, decides which animals get special protections. Do you think the law should distinguish between livestock and pets?
For horse racing and making money, and that's justifiable.
Well, that's something that needs to be taken up with the legislature on the fact that maybe people don't want horses being beaten. I know some people complain about maybe in other countries, dogs are eaten for food, but then people have a different idea of how dogs should be treated as opposed to livestock, as opposed to horses, as opposed to chickens. But that's something for the legislature to change how different animals are treated and how they're treated in sports. So my understanding, and again, if I'm wrong, correct me if I'm wrong, the state is not charging your client with emotional abuse.
No, Your Honor.
So my understanding there that the indictment doesn't mention emotional abuse. And I know you're saying torture, but my understanding from this statute and from what the state is saying, they're not charging your client with emotional abuse of an animal. They're charging her with allegedly, recklessly causing torture or committing torture.
So, first, let me back up and say that the legislature has, in their infinite wisdom, not distinguished between livestock and non-livestock for purposes of torture. And so we cannot say that animals, livestock should be treated differently than non-livestock. They all are examples of what a collective class of they're a collective class. So we can't distinguish it that way. But what the problem is not whether the state sits here and tells us what they've charged. It's that the statute itself, the underlying statute, is so broad as to encompass or not eliminate the ability for someone to be convicted, including my client, of an instance in which all that happened was, if anything, emotional harm to an animal. And that's the problem with the statute. Whether the state claims that they weren't trying to, convict someone for emotional harm, it's that when we get to the end of this in that jury charge, and I go and ask the court, hey, how are you going to keep them from convicting on emotional harm alone? The court's not going to have an answer because the legislature didn't give us the tools.
No, here's the thing. I'm reading the indictment. The indictment is stating intentionally and knowingly, recklessly torturing an animal. Like if the state were to just have left that as says torturing an animal, I would say your client really doesn't have notice. What are they talking about? But then in the indictment, it says, namely a dog, by repeatedly. There's no mention in this indictment about emotional harm. And whether or not you believe a jury may or may not find somebody guilty because they're thinking about emotional harm, that's something that you'll need to argue with the jury.
And Your Honor, and that's where I'm saying I have an issue with the law itself. That's why it's filed as a motion to quash, because this is something that a jury, it can't comprehend how the laws are structured in our country. I mean, they haven't studied the laws like we have as lawyers.
But isn't that what a jury charge is for? I tell them in a jury charge what the law is, and they have to follow the law.
Yes, but you told them, and right now what I'm explaining is that there is no limitation on it being. So if what the court, if I'm understanding your question correctly, I think your question is, hey, can a jury convict on emotional harm? And that's the issue, because it is read that broadly. You're not going to be able to tell them no. You're not going to be able to tell them you must find at least however that's defined, because we as a society do not find emotional injury to be a criminal act. It would be criminalizing non-criminal conduct if we are saying you can convict on emotional harm alone. And that's the problem, is that when I ask you for the jury charge, you're not going to be able to give me a jury charge that is in line with how it is supposed to be. In my opinion, it is supposed to be limited to injury, but you're not going to be able to do that because the law is absent or silent on that. And also further, if we are to say, okay, well, it's silent, we can look at, and section under Texas Penal Code 105, it tells us that we are to read these statutes, these provisions, in line with the whole context of the Texas Penal Code to be a fair interpretation of the statute. And I have a hard time believing that the legislature allows us to give effective consent for someone to cause our animal bodily or poison and cause serious bodily. But they're like, but you can't cause them emotional harm, and that it goes that far. And so what I'm saying is that if there is a way that the state could have indicted this that would have limited it and applied it the way it was probably intended to be, they would be causing that they cause bodily injury by repeatedly striking the dog, because they then, in their manner and means, have limited it and said, look, we're talking about bodily here. We're not talking about whether the dog was traumatized with no bodily.
The dog would be a question of fact for the finder of fact of the jury. We would just urge, Your Honor, that the statute is not unconstitutionally vague and that any issues regarding what may or may not be torture would be a question for the jury.
All right. And defense, it's your motion, so I'll give you final argument.
Well, and Your Honor, I still have, there's other
Sure.
things that we need to address. So I would like to provide y'all with a copy of United States versus Stevens, in which the federal government dealt with a statute very similar to this one. In fact, it was more specific. It said that the statute required proof of being maimed, mutilated, and tortured. The U.S. Supreme Court said this statute is unconstitutionally vague. And they explain why. And torture is even as defined as unjustifiable pain is even more vague, because when we look at all the ways our society allows us to put bark collars on dogs, they allow racing, they with the crops, they allow branding of an animal, they allow and none of this, like when you take pigs, little baby pigs, they cut their ears and they do it deeply enough so that it can't heal again back and close back up. They pull their teeth without anesthesia. They crop their tails. They do this thing called mulesing to sheep, which they take scissors and cut off their back side so that the hair won't grow and they won't get infected. I mean, we do very, very painful things to these animals without anesthesia, and they are accepted. Museling is not illegal in the United States. And what I am afraid of is that in the United States, we feel that a parent has the right of discipline of a child, and there is no provision in here for discipline of an animal. And this statute as written is so overly broad that unjustifiable pain and suffering, I mean, unjustifiable suffering, someone might think crating your dog is unjustifiable suffering because they personally see it that way. This is so broad as to not give an ordinary citizen notice of what is actually actionable. And I would also bring the court's attention to this. Every case that I've looked at with torture has a severe degree of depravity. It is not, and it doesn't come without bodily. I have not found a case that has no bodily. And so if this statute is broad enough, because pain is so broad, pain encompasses bodily and emotional. If it's so broad, you have now allowed the jury to, because of the breadth of the statute itself, to convict for what we would consider acceptable behavior in our society, crating, leashing, bark collars are sold, shock collars, shock prods. I mean, we don't treat animals the same way that this statute is as written, the breadth of its statute could reach. Yeah, and then also when you look at the term for torture, it says includes. It doesn't say is any act. So it's even more broad. They leave it so broad that I do not think an ordinary citizen can fairly know what this statute's limited to. Now, finally, what I wanted to bring the court's attention to is the very last section of our paper, of the memorandum, and it talks about whether this is a result of the conduct crime or a nature of the conduct crime. And that really matters for two reasons. One, if it's nature of the conduct, which is what the committee in their notes believed it was, then you can't recklessly engage in the nature of a conduct. And so we would ask for the recklessly to be struck. However, the committee also noted that it might be, if it's seen as a result of the conduct crime, then you have to have a result. And in here, all they did is provide the conduct. They did not limit it by giving the result that we are supposed to be defending against. And so the indictment as pled would not be sufficient under result of the conduct to proceed. And we would ask that it be quashed for that reason. And then finally, I would argue that the way the indictment is pled in and of itself shows that it's legally insufficient to be, to prove torture, because it does not provide any accusation of what pain was suffered or that there was bodily pain or injury. And therefore, because all they've said is repeatedly striking, and by law, by common sense, we've seen that our society accepts horse racing and beating of horses with hard stuff, that I think that on its face, it is insufficient as pled to prove torture. It needs something more than just repeatedly striking a dog in order to constitute torture.
Your Honor, defense keeps mentioning horses in the acts that we commit against these types of animals. However, those are livestock animals. In this case, we're dealing with non-livestock animals. These are typically in this case, cats, dogs, those kinds of things that aren't subject to the same kind of normal use and practices like a horse would be, as well as the argument about the result of conduct. She stated that we need to have a result. In this case, the result would be torture to the animal by the conduct of repeatedly striking it. And then as well, the case that was provided, I don't think is applicable here just because of the facts that we have.
All right. In the Stevens case, is that relating to First Amendment rights and the violation of First Amendment rights?
So it is a First Amendment rights case, but their interpretation of that statute as being vague is what the analysis.
But isn't it because though they were saying that it's a violation of First Amendment rights?
Well,
to
and
depict certain photos, and it wasn't about necessarily about the acts against an animal. It was more about the right to free speech.
I think the bigger part of that, Your Honor, was that the statute in that case criminalized non-culpable conduct. And the court discussed that at the end when they say that this statute is so broad to even encompass, in that case, hunting videos or something that's non-culpable. The statute was so broad, similar to, what we're dealing with here, to encompass and criminalize non-culpable conduct. And I think that the issue is the same here, and that statute was even more specific than a good deal more specific than this statute.
But it's about First Amendment rights. I understand that sometimes you will have appellate courts. They will make a ruling on the issue that is specifically before them. And then you may have other members of appellate courts who will do a dissenting opinion or a consenting opinion, and then they want to add things that's not really about the issue at hand, but more as a signal to everybody to say, hey, this is what we're considering in general. But that case is about First Amendment rights and whether or not you could post videos of people being cruel to animals. Wasn't that whole statute related to the posting of videos and not necessarily about what we're here for today?
Well, in effect, that was the intent of the statute, was to ban crush videos of animals. But in practice, and when applying the statute as broadly as the court found that statute was written, it encompassed a lot more than just animal crush videos, including, like I said, hunting videos, other things that, are generally accepted practices that, we would consider non-culpable. And I think that's the bigger issue with it. It encompassed more and criminalized more conduct than necessary, without, a level of specificity to give the average person notice of, what conduct that the law is criminalizing. And I think that's what the problem was in that case. I think that's what the problem is here.
So with regards to the Stevens case, it appears that Congress changed the law and they made it a crime to knowingly create, sell, market, advertise, exchange, or distribute any Animal Crush video. And then they define what Animal Crush video is that depicts actual conduct in which one or more non-human animals is intentionally crushed, burned, drowned, suffocated, impaled, or otherwise subjected to serious bodily injury, and two, is obscene. So they address that. But in this case, the Stevens case, it was about First Amendment rights. And you say you want to address something with First Amendment rights here?
Yes, because conduct is also First Amendment also reaches conduct, and in this instance, there are First Amendment rights. We have a right to conduct our lives in First Amendment, like in our actions, in our words, and there are words that are taken in this instance, as well as actions that substantiate or like back up the words that are used. And she has a right to express herself, and her belief of what is right and wrong as far as discipline is protected by First Amendment. Whether we agree with that or not, someone's position, they still have the right to express themselves. And here, I do believe it's broad enough to also trigger First Amendment rights because she's talking, she is expressing a position and what.
And we've come full circle. The defense is doubling down, claiming that the defendant was expressing an opinion on discipline through her actions. It's the ultimate Hail Mary pass. If the judge buys this, it could change how animal cruelty is prosecuted in this district forever. But as the judge points out, none of this expression is actually in the indictment. The clock is ticking on this motion. What do you think the ruling will be?
And so in that regard, if you were to criminalize this, you'd also be triggering First Amendment rights of what someone believes. And it was on a video that is then publicized.
All right, what do you mean she's talking and expressing an opinion? Because I don't see that in the indictment. Is that some fact issue?
Well, it is that it reaches that, like that First Amendment is going to be triggered because she does express an opinion as to why the dog is being repeatedly struck. And so it's all in the context of.
All right, when you say express opinion, I'm trying to understand. I'm sorry for interrupting you, but I'm trying to understand your argument. When you say she's expressing an opinion, are you speaking about your client?
Yes, there is in this case, there's an opinion stated. So this case is broader than just act. It's also speech, it's conduct, and repeatedly striking is a conduct in regards to discipline. And so discipline is protected by the First Amendment. You have the right to discipline and speak your discipline and to conduct your discipline.
Okay, I'm sorry. I'm trying to understand your argument because it appears that this is beyond the indictment, but are you saying that your client made some statements in its protected speech?
Yes.
All right. So does that go with the voluntariness of her statement argument?
No, that is a separate.
I don't see how the court is legally allowed to go outside of the indictment when you're saying a motion to quash, because now you're bringing in facts that are not in the motion. That are not in the indictment, because nowhere in the indictment does it state that there was a film. Nowhere in the indictment does it state that your client gave statements. So it appears to the court that what you're arguing now are fact issues. If the court denies your motion, they're fact issues for the jury, not for a motion to quash.
And I understand the court's position and agree that was probably more as unconstitutional as applied argument that would be more appropriate at the end of a case than right now when we're just looking at the face of the document of the indictment and the statute. But I would just say that repeatedly striking a dog is conduct, and conduct is protected by the First Amendment.
So you're saying a dog is a form of speech?
Yes,
All right.
because it's a form of conduct that it is by its essence related to discipline, care, control of your animal.
So then any type of conduct, be it against an animal or a human, then would be a form of speech.
It could be, but it could also not be a protected form of speech. That's possible.
All right, State, she's saying animal is a form of speech and it's protected.
Your Honor, we were just asking you to look at the indictment on its face. We haven't alleged anything about discipline, anything about speech, anything about a video. We've merely alleged torture. By repeatedly shooting the dog, we would assert to the court that regulation of conduct only implicates the First Amendment if it qualifies as expressive conduct akin to speech. But I don't see how it applies here, really.
All right. All right. With regards to the motion to quash, the court has heard arguments from both sides. The court has reviewed the case law that has been submitted to court. The motion to quash will be denied. The motion in limine regarding social media and news coverage. What I can tell the parties, people always assume that I know facts about a case. I don't know any facts about the case, believe it or not. I just read a lot instead of watching a lot of news. So I'm reading your motion in limine regarding social media and news coverage. Just give me a moment. All right. So with regards to news coverage, this is what the court proposes. And if anyone has any objections, let the court know. So usually what I will do, if you all will give me some information about the case, and if you both can craft a question, because I don't know any of the facts of this case, if you can craft a question that you all both approve of, I will ask the jury if they ever heard of this case before, right? Because I don't know where this is alleged to have taken place. I don't know anything about this case. So if you all would give me a question perhaps that you all would like me to ask the jury about whether or not they've seen anything regarding this case, then I will do that. So is there any objection to that?
There's not, and that's kind of what I set out in the second paragraph is
Mhm.
kind of my hypothetical of how it might be addressed.
Yes. So if you all will confer on that, and then we can put on the record the question that you all propose the court ask, and I'll ask that question. But if I had more alleged facts about this case, I would have a better idea of what question to ask the juror. But we can most definitely make sure that they haven't heard anything. And then if they have stated that they've heard something, I'll question them separately.
Thank you. Yeah. That way, my concern was poisoning the jury for someone saying like everything they saw.
Okay.
And Your Honor, if I can, with the state's permission, just tell her just briefly the social media extent. Okay. So there was an alleged video taken of an incident in which it's claimed that Miss Miller shot the dog 15 to 17 times. And then it's posted all over social media. And there's been death threats, gang rape threats, and everything under that. It's been on the news. It's, I don't know, Facebook. I mean, and so my concern is just that I don't know exactly how.
Well, here's the thing. If you all get together on a question, in my mind, currently, I'm thinking just asking them, one, if they know your client, two, if they've seen any type of video in Bexar County, because I'm assuming this happened in Bexar County, because otherwise we wouldn't be here, or it's alleged to have happened in Bexar County. And I can just ask them if they are aware or have seen any videos where someone is alleged to be stalking a dog.
Okay.
So that's what I'm thinking along the lines of having that. But again, if you all confer and decide on a question, we can discuss how the question is presented to the jury.
Okay.
You're charged with cruelty to non-life animal as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. If you would like for a PSI and a TAP evaluation, that's 12 weeks. Or if you would like to just reset it and bring witnesses, we can have it brought sooner.
I believe the 12 weeks, if we can do that, to have a full assessment for the court. And then, Your Honor, in regards to, we had already preserved our rights as the constitutionality challenge on a motion of quash on its face. But at this point, I would also assert to the judge constitutionally as applied. And now that we have the evidence in and the facts, I would like leave of the court to at least file that motion as applied and get a ruling and have a ruling that day.
File that motion.
Well, so on a motion to quash, you can't do unconstitutional as applied. You have to wait until the judge.
No, I mean, what motion?
A motion objecting to the constitutionality on as applied. It's timely after there's been an adjudication of guilt. So I just want leave of the court to file that motion and get a ruling on it.
Oh, everybody can file whatever they want to file and I'll hear it.
Fair. Because I know right now we're talking about appeal, and I think you'll wait until after the sentencing to do the trial rights certification of appeal. Is that correct? So I just wanted to kind of give the court heads up as to the constitutionality as applied, that we're trying, or our intention is to preserve that. Okay. Thank you so much.
Thank you. What date? All right. You entered a plea in this case, and the court has previously stated on the record what the plea bargain agreement consisted of. Where we left off, the court asked if all parties had a chance to review the PSI report. And defense, have you had a chance to review the PSI report?
I have.
State?
Yes, Your Honor.
Any corrections to the PSI report?
I have no corrections to the PSI report. I do need to follow up on one thing after the statement.
All right. Any corrections to the PSI report? All right. Any witnesses from either side?
Yes, Your Honor. State has 3 witnesses.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. State your name for the record, please.
Havana Dujane Miller.
All right, defense, you may proceed.
I asked you if there was anything that you wanted to say to the court before you were sentenced, and you said that what was your response to that?
There is, that I do want to say something.
Okay, and this is your opportunity to speak to the judge. What would you like to say?
So, Your Honor, I would like to say that I completely understand that my actions were not okay. I did allow a moment of overwhelmed, being, frustrated to take over me. I do take this whole thing as a learning lesson, and I'm sorry that the puppy had to be part of this learning lesson, but I have learned to control myself, to have more patience. I'm sorry to everyone involved, including the puppy, even the people that have been against me in this, social media, the people that came in today. I'm sorry that they had to see that side of me, because I know that that's not who I am. And I'm sorry to my mom. I'm sorry to my family, my nieces and nephews that were threatened due to this. And I know that that's not something that I would ever do again. I'm not a troublemaker. I go to school, I go to work, and I spend time with my family. I'm not a danger to society. And again, I allowed a moment of frustration to take over me. And I'm sorry that I had to learn these things this way. It shouldn't have taken this. And I'm sorry that it did. And again, I'm sorry that the dog had to be part of this learning lesson for me.
Okay, and I'd also like to ask, you are employed right now, correct?
I am.
How many hours a week do you work?
Right now, I'm working 50 hours a week.
And in addition to being employed, are you going to school?
Yes, I am.
And what are you going to school for?
I just don't feel comfortable saying that only because of social media.
Okay.
But I would tell the judge, I could write it down.
No, it's okay. And in regards to that, are you currently taking classes?
I am.
Are you, the state has asked for a jail sanction. You're aware of that? And, in regards to that jail sanction, is there a reason why you do not think that that would be appropriate here? Okay, and why is that?
Because like I said, I have learned this would be a major setback for me. I get all A's, I get A plus, I have a 4.0 GPA. It would set me back on something that I know that I'm not going to cause trouble. I'm not going to cause trouble to anyone. And it would also set me back with my job. I need my job to pay for my school. So it would just set me back, and I'm not a danger to anyone.
And at this time, I'm going to pass the witness, Shauna.
I have no questions for Ms. Miller, Judge.
I do.
Yes.
So, do you currently own any pets?
No, ma'am.
So tell me, what was going on in your life at that time that it came to this point?
At that time, and still to this day, I have been grieving. I'm grieving my dad.
Mm-hmm.
It's hard for me to talk about, and I hold it in a lot. And again, that doesn't give me a reason to do that to the puppy. Mm-hmm. But I did allow it to take over me. I had been up all night, but trying to potty training, and I had got up again early that morning, and it just, at that time, that's what was really, really heavy on my mind. Of course, there's other things, but that's the main thing.
So did your father pass before or after you purchased this animal?
Before.
All right, so he passed before, and you decide to take on a pet in your life. So I don't understand how you get to the point where a puppy with a belt or a strap. I don't understand how you go from that to this, and it's a puppy.
Right.
And when puppies use the restroom inside the house, you know whose fault that is?
It's mine, but that was not the case.
So then why were you being frustrated with?
I was frustrated that morning because I had taken him out to use the restroom, and it was really cold. Again, this is not his fault. It's mine. But he was doing that thing that dogs do, like when you're trying to get them, they're not ready to go inside, and he kept running away every time I would go towards him, running away and playing around. And I was personally not in a play mood, and I took him upstairs. That's not when that happened. But then I was trying to leash train him, getting used to his leash. And I saw online that to leash train them, you can put the harness on them, put the leash on the door, so that way they can get used to it. Of course, giving them room to still walk, but right there. And I guess he had got frustrated with that, and he did do that. And that was what caused me to do that. Again, it's not a justifiable reason.
So why did you have him, how long did you have him on the leash on the door?
It was only about 30 minutes at that time.
And so you didn't notice that he was biting through the leash?
No, ma'am, because I was inside and he was on the balcony.
All right, so outside on the balcony, biting through his leash.
His harness, yes, ma'am.
And his harness. I still don't understand how you go from that to a puppy.
Just allow.
And so I'm trying to understand how you get to that point. First, you've taken on a puppy. Your father, as you stated, had already passed, but you decided to take this puppy on into your home. And then we get to a point where you're striking a puppy on the balcony. I'm trying to figure out how you get to that point, because puppies are going to do what puppies do. And when puppies come to you, if they're puppies, right, depending how soon they were taken away from their mothers, usually they come to you and they're not trained. So you took on a puppy that wasn't trained. I still don't understand how you get to the puppy bites through the leash, and you're saying it took 30 minutes for him to bite through the leash. So you had the puppy outside on the balcony in the cold, because you said it was cold outside, by a leash, and he bites through the leash. So I'm trying to understand. Because I will tell everybody, I'm inclined to follow the agreement that you've reached. Now I'm trying to consider, because the state is asking for jail time. So I'm trying to weigh things here, because my intention, if I'm placing somebody on probation, I'm not trying to ruin their life where they can't go to school or they lose their job. But rehabilitation sometimes is just not rehabilitation. Sometimes it's punishment thrown in, right? And it appears that your punishment may be, the fact that you're on probation. And I have to make a consideration whether I give you deferred or give you a conviction. All right, so that's what I'm trying to understand. How did you get to that point? Because you're saying it's cold outside, but you have a puppy on the balcony. And how big was this puppy? Is it one of those puppies that sit in your hand?
He wasn't that small, but like they said, he was about 3 pounds.
All right, so how small?
He was like this.
All right, so you have a puppy who's sitting on the balcony in the cold, strapped to a door or whatever, because you say you're trying to teach him how to be on a leash.
Again, I got that from online. It wasn't punishment. I was genuinely.
Oh no, I understand you're saying you got that online, but I'm trying to get to the point of you place him on the balcony. He's been running outside playing around. You don't have time to play. You got other things on your mind. You just want that puppy. Do your business for the love of all that's holy. And I'm taking you inside. And I don't know, maybe puppy's yapping around in the house. And then you're like, you know what? Go out on the balcony, learn to be on a leash.
So outside on the balcony, I did have his crate with blankets. Whenever I would go out there, he felt warm. He wasn't shivering or anything. Mm-hmm. But to answer your question, Your Honor, getting to that point, I would just felt overstimulated. I felt frustrated. And at that point, I just let my emotions get the best of me at that point. I do feel that from January to now, I have changed. I'm not saying I'm a completely new person just yet, but I have learned to control my emotions better. Don't just get angry so quickly, or, actually speak about what's going on in my mind. So that way I don't hold it in and things like that happen where I lash out. And I allowed that to happen.
All right, and what is this about the witnesses testifying that they wanted to buy the dog from you and then you're increasing the price? What's that about?
So that was because when she came to my door on the Ring doorbell, I did say, as she said, that 2 cops had already came and checked on the dog and he was completely fine. She mentioned, well, I don't feel comfortable. I'm not going to be able to sleep tonight if you don't give me the dog. And I'm saying, basically, that's my dog. I don't have to give you the dog just because you want my dog. And so long story short, I was, frightened by the fact that she was threatening with the police. So I said, okay, well, if you don't get police involved, because I knew she had a video and she had it posted on her Facebook. At the time, I didn't know it was her Facebook. She just told me that she saw it on this neighborhood website or neighborhood app. And she told me that she saw the video online. I was asking, well, how did you even find me? And she said that she looked at the balconies and she did see the dog out there on the balcony.
Let's get to the money, the exchanging of money or not exchanging of money.
The money part.
The witness testified, and right. You can correct me if I'm wrong, right? But I recall the witness testifying that you all had maybe agreed on a price. Then after you agreed on the price, then you upped the price. And Then she said she had to post some video in order to raise funds so that she could purchase the dog. So let's talk about that.
Okay, that did happen. And she did offer me $300 because, like I said, I was frightened that the police were going to come. So I was willing at that point to do that. But then I thought about it and I said, I didn't want to just give up my dog. I did love my dog. And
so then why did you increase the price?
Because I felt that if I had paid $1,000 just to get him, I had done the shots and everything for him. He was up to date on everything. I had bought him, all the supplies that he needed at home, food, things like that. So I just felt if she really wanted the dog, then she could at least pay the minimum price of him, which was $1,000 to get him.
All right. And did you talk to family members about what was going on in regards to this case and what was going on in your life?
Yes, ma'am.
Did you tell them, hey, I need some help? Can anybody take the dog?
No, I did not. I don't have people that I believe would have been willing to do that.
Okay. All right. Any other questions?
A couple follow-up questions.
Sure.
Okay. Your dad, you say passed away after you got the dog? Before. How long before?
2 years.
2 years. Okay.
Not even like almost 2 years at that time.
Do you know what the date was that he passed away?
He passed away June 17th of 2022. No,
Of
yeah,
2023?
June 17th of 2023. Sorry, it was because he was brain dead and then they donated his parts, so he wasn't actually dead.
Okay. And so, did you adopt the dog or get the dog as a way to cope with any kind of mental health issues?
I did, yes.
And during this time period, were you getting much sleep when you had the dog?
I wasn't.
How long did you have the dog?
About a month or 2 months.
Okay. And so you were a month or two with no sleep, correct?
Mhm.
At this time. Do you think that your lack of sleep and your mental health situation put you in a position to not use better judgment?
Yes, ma'am.
Okay. At this time, Your Honor, I pass the witness.
All right. So I can tell you your versions of events, and I understand what you're saying, and maybe you just skipped over a little bit. In the PSI, your versions of events are, I was tired and let my emotions get the best of me. I was at home at the apartment. I had just been up early as I had a late night. I was trying to potty train a pet that was involved in this case. I saw the dog's harness. I got them. I had taken them out and they didn't go. They had an accident. I got upset as the new harness was chewed up. All right. Is there any other questions? Any other witnesses?
I don't have any other questions.
All right. I'll have you all come back at 1:30 and I'll make my decision at that time.
Okay.
All right. Thank
And,
you.
Your Honor, I would like to at least have an opportunity to make a close.
No, you all will have an
Okay,
opportunity.
thank you.
All right. Is there any other evidence to be presented by either side?
And not by the defense.
All right. Court will hear brief argument.
Thank you. Your Honor, first off,
Yes.
Judge, I'll reserve,
All right. Go for it.
first off, we're not condoning the behavior, but I think we need to keep it in perspective. I understand that a video caused sensational backlash, but the reality is there's no visible injuries to the dog. The dog was not physically maimed in any way. And when you think about that, in our justice system, we don't really honor an eye for an eye.
Mhm.
But in this case, probably the more appropriate punishment, in addition to having been humiliated socially. And that is a huge thing. This has been a very difficult situation for her to live through, being threatened and all of that. But, it's a flaccid leash. And when I went to high school, they did corporate punishment. I don't see, if this is so egregious, then the punishment really should match the crime and have her ordered to be struck 17 times with the same leash that she struck the dog with. That's more appropriate. But I disagree with the fact that the state is asking for a jail sanction here. This young lady has no prior criminal history. She got straight A's. She is employed. And again, like I said, neither she nor I are condoning her behavior. She's taking responsibility for it, but it needs to be kept in perspective. In regards to her being a first-time offender, no rehabilitation or mental health has been given to her at this stage. So I believe that would be appropriate. I am asking the court to consider the fact that torture, while the court has found that it is sufficiently met, the elements sufficiently met here, there is no lesser included. And it doesn't even require bodily injury. So on the scale of this particular type of offense and the things that we see in our practice, you and I have, I think, been doing this for over 20 years. You know, we have seen egregious cases that fall on the scale that are very offensive. And while this is not something that we condone, I do not think it falls on the extreme of this type of offense, even if the court believes the elements were met. I am asking the court to grant her deferred adjudication, give her the ability to prove herself. I believe that with no prior criminal history, we shouldn't jump into any kind of jail time or prison time for that matter. And I'm asking that the court order anger management and all the things that the pre-sentence investigation we're talking about, with the exception of a jail sanction. I also want to point out that in the pre-sentence investigation, she stated that the way that she was raised was discipline was love. It was synonymous, that if you weren't disciplined, you weren't loved. And I'm not saying that, again, no one's trying to excuse the behavior, but I think that's an educational thing. She was treated the same way growing up, and it's something that we do need as a society address, and some of maybe the way we see things, and maybe even the way that society sees things and does things openly, and does it and is condoning openly to animals. Like, for instance, shock collars that are sold. You know, there's things that our society accepts, and while I'm not saying that what she did is acceptable, I just don't think it rises to the level of being as egregious as it may have appear on the video. Based off of the actual result. And I believe this is a result-oriented crime. And so we're asking the court to give community deferred adjudication.
Okay.
Thank you, Your Honor.
All right, state.
Your Honor, state is asking for community supervision with the 180-day jail sanction based on the fact this is an egregious act. Thanos was a 3-month-old puppy that was defenseless, and although he's not verbal, cannot speak with words, that video speaks for itself. He was yelping in pain as she struck him what appeared to be 17 times while muzzling his mouth, presumably to keep him from making sound. Miss Miller testified here today that it was cold outside, and he initially was outside for leash training. When she came into the presence of officers, she told them he was outside because he had soiled in his kennel. She told you today in court that he was out there with blankets, but as you can see in the videos, that's not the case. She initially lied to officers during the welfare check. She said nothing was wrong and that others had dogs in the unit, knowing full well that she had just struck Thanos and that the officers were aware of the fact that she had done that because they saw the video prior to making contact with her. Her acts were callous. He was muzzled and she struck him. He got away and she continued to hit him. Defense would have the court believe that not all 17 blows were to Thanos, and she mentioned the pop-up kennel. However, in the video, you can see that pop-up temporary kennel wasn't moving as if she was hitting that kennel instead of the dog. She then agreed to sell the dog to Miss Rubio. First, the price was $300, then it went up and up again once she realized that it would be an inconvenience for her to not break even. And I would assert inconvenience would be a theme here today. Miss Miller states that she cannot do a jail sanction because it would be an inconvenience to work. It would be an inconvenience to her life, but that inconvenience should have been thought of prior to even getting a dog for ownership. She testified that unfortunately her father passed away in 2023, but this incident would occur a year and 6 months later approximately.
So this is what I'm going to tell you. When I have cases before me, I look at each case individually, right? Because somebody will come before me, and I've had people argue before me, oh, there's somebody who had an aggravated assault with a deadly weapon where they shot somebody, they got probation, didn't get jail time. So I always try to remind people that each case is different. That's why I look at cases individually. I don't try to figure out, oh, this is what happened in this case, or this is what happened in this case. I just have to deal with the facts that are before me, right? And I understand everything that your attorney said. I understand that you don't have any criminal history. I'm going to give you a choice. Sometimes I can give people choices, sometimes I can't. But these are your only choices. And I'm going to give you a chance to discuss it with your attorney before you decide. All right? So here's your choice. One, I will either give you deferred adjudication, and I will give you deferred adjudication. I don't think 10 years deferred. I'll give you 8 years deferred adjudication. Or with that deferred adjudication, you're going to do some jail time. Or you will have a conviction and I won't give you any jail time, because sometimes, well, not sometimes, really all of the time, cases are about rehabilitation, but there's a form of punishment in it. So your only choices are, I'll give you deferred adjudication, but you'll do some jail time as a condition, or either you'll have a conviction and you won't have any jail time as a condition. I'll give you a chance to discuss that with your attorney.
Thank you.
All right, have you had a chance to speak with your attorney? And which do you prefer?
She would take the probation, the conviction.
All right. All right, so the court will find you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Proof of employment within 30 days or full-time study within 30 days. There's to be no employment as a home health care provider or with minors. 150 hours of community service restitution. Is there anything else you need from the court to be successful on probation?
I would like clarification on how do I prove my work in my school?
Oh, probation will go over that with you. All right. Anything else? Anything?
Not this time.
Okay. Anything else from the state? All right, we can go off the record. Here's the thing. Animals are helpless, right? And they depend on you to provide for them. And if you don't have the patience to have a pet, then guess what? You shouldn't have a pet. The end of story, because they depend on you for food and everything. And maybe people shouldn't be beating horses as they run around the track at full speed. I don't watch it, right? But our society doesn't equate racing a horse around the track with pets, right?
Yes, ma'am.
Bullfighting, should there be bullfighting? But they don't equate that with pets. Maybe one day they will, but for now they don't. And so you're not allowed to have any pets. And you're not allowed to babysit children. You're not allowed to do any of that. Do you understand? All right, there is a pause. Are you babysitting?
I have nieces and nephews and I've never done anything to them.
No, you're not allowed to babysit. And let me just explain to you why I'm saying that. Because your patience with your pet, you lost it. And at this point in time, you cannot babysit children at all. You understand?
Is that just during probation?
Yeah, I mean, I can only order what I can order, and no gum chewing. I can only order what I can order while you're on probation. So for these 8 years, yeah, no babysitting. Okay?
I do have a question. I'm sorry.
Yes.
If I don't plan on it, but 8 years, I'll be almost 30. If I wind up pregnant or have my own child at that time, what's the difference?
Here's my thing. I always tell people, let's not cross bridges until they're built.
No, it was just a question.
No, that's what I'm saying. I can't see in the future. I don't know how you're going to be doing on probation.
Right, but would I be like in violation?
What she's saying at this point is she's gonna
Just don't let it.
label it. If it becomes an issue, we'll put that forward.
And your attorney can approach that on, because you can see there are many circumstances where you're telling me that, and then maybe it wouldn't be appropriate. But then if it wasn't appropriate, Child Protective Services would probably be involved, right?
Okay.
So I can't look into the future and see how you're going to do. But what I can tell you is we'll cross that bridge if we come to it. All right?
All right.
All right. Thank you.
Thank you, Honor.